Honorable Supreme Court of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Thank you, Mr. Hibner. Good morning, everyone. Good morning to counsel for our next case. Good morning to those of you that are watching our live stream broadcast on YouTube. This is the day 2 of our oral arguments for the Nashville November 2020 docket for the Tennessee Supreme Court. We are happy to have everyone with us. We have been doing these oral arguments by video conferencing for a number of months now as a part of our way of handling the pandemic to balance the health and safety of everyone involved with our judicial system with the need to make sure that our dockets continue to move forward and that the justice system does continue to operate as efficiently as possible during this difficult time. While it's not the same as being in person, we have found it to be an efficient way to move our dockets forward. Realize it's all of us have had to step outside our comfort zone to some point with this type of proceedings. But again, we have found that it does work well for us and allows us to move forward. We will make every effort not to try not to talk over everyone. That becomes difficult sometimes, but we'll try to let you know which justices, for the lawyers, we'll try to let you know which justice is asking the question, and we'll go forward in that manner. When we begin in just a moment, each side will have 30 minutes for argument. If the appellant wishes to reserve any of the 30 minutes for their argument, please let us know at the beginning of your argument. With that, Mr. Hibner, I'll turn it back to you to call our case, please.
Re Mattie L.
All right, Mr. Johnson, you ready to proceed?
You're muted.
You're muted.
I'm sorry, I thought I unmuted myself.
All right, there you go.
Good morning, Your Honors. I am Mitzi Johnson. I represent Rebecca and Stephen Godek, and I would request 4 minutes of rebuttal time.
All right.
This is a termination of parental rights case that was filed on December 19th of 2016, and there are 3 main issues before the court this morning. The first is whether or not the application of the missing witness rule is solely reserved for jury trials, and whether or not its application in a bench trial violates due process of a fundamentally fair trial. The second issue is whether application of the unclean hands doctrine to affirmative relief in an answer also violates the due process of a fundamentally fair trial. And the final issue is whether or not grounds for termination exist in this cause. I would submit to the court with regard to the issues of the missing witness rule and of the unclean hands doctrine, if the trial court was in error on either of those, that it was harmless error. In reference to the actual missing witness rule, Crencor Leasing and Sales versus Gann and Elshett versus Hatfield found that the missing witness rule application was harmless error. In this particular case, the trial court applied the missing witness rule because the defendant did not appear for trial. He was in jail across the street at the Shelby County facility on Poplar Avenue. The Court of Appeals, however, found that the missing witness rule does not apply in bench trials, and that by virtue of its application, that the defendant's due process rights to a fair trial, fundamentally fair trial, were violated. I cited numerous cases in my briefs, and I will not go back through those for the court because I know you have that in front of you. But the numerous cases that I cited, there were several in which the Court of Appeals upheld the application of the missing witness rule in bench trials. There are also several cases that I cited where the missing witness rule was contemplated in bench trials, and the Court of Appeals did not say that that contemplation, and the Court of Appeals did not say that those applications were in error. They also did not find that they were in violation of the due process clause. What I would submit to the court is that this particular rule is tantamount to a negative inference when a party pleads the Fifth Amendment. In the cases in which this is cited under State v. Middlebrooks and State v. Francis, where it states a party is entitled to argue, and then it quotes, and have the jury instructed. And have the jury instructed, this is the English major in me, is separated by commas. It is a phrase that can be removed from the sentence, and thus, if you remove that sentence, a party is entitled to argue that if the other party has it peculiarly within his power to provide a witness whose testimony would naturally be favorable to him, the failure to call that witness creates an adverse inference that the testimony would not favor his contentions.
Ms. Johnson, I have a question. This is Justice Lee. If the missing witness rule does apply, it is only an inference, yet Chancellor Evans twice in his order talked about a presumption. He presumed that the testimony would have been unfavorable, and he referenced a presumption that the testimony would have been unfavorable. So even if it applies, didn't the Chancellor misapply the rule and give it too much weight?
I don't think so, because nowhere in the record does it ever shift the burden of proof to the defendant. The burden of proof was always with the plaintiff. In Gentry versus Gentry, which is actually a 2001 case, in that particular case, the trial court referenced it as a presumption as well, and the Court of Appeals upheld that. In, I believe it's my responsive brief, I cited under Black's Law Dictionary the definitions, and under a permissive presumption, that is also termed a permissive inference, which is exactly what the missing witness rule is. It says a presumption that a trier of fact is free to accept or reject from a given set of facts. So I think his use of the word presume is synonymous with the word infer, because I do not believe that his use of the word presume created a presumption and transferred the burden of proof to the defendant.
Under that rule, the witness has to be available. And if a man is locked up in jail, he can't just stroll across the street and attend a trial. So was he really available?
He has to be available to the process of the courts. And yes, I would submit to the court that he was available. A subpoena could have been issued, and he could have been requested to be brought over even absent a subpoena. In fact, on the record, counsel for the defendant stated that she had made no request to transport. So I do think that—
I'm sorry, that was a strategic decision to make to keep you from calling the defendant as a witness to prove the willfulness of the ability to pay or the non-payment or visitation?
I believe so. And I believe that throughout the record that there were statements made that the trial could proceed in his absence. So it was a contemplated decision, is what she referenced to the appellate court.
Ms. Johnson, this is Justice Page. If we agree with you that the missing witness rule does apply in bench trials such that the Court of Appeals were in error, what is your position on how that impacts the final resolution of this case?
I think that the facts of the case and the entire record would need to be reviewed under that negative inference for defendant's failure to appear. It goes to the weight of the evidence, which is adverse to the party who failed to call the witness, and it's supposed to enhance the evidence of the party, of the opposing party.
Counsel, this is Justice Kirby. If that is so, when you address the grounds, I would like for you to specifically point out where you think that negative inference should be applied, because the trial court did not, and that bothers me. It's one thing to say, well, he said presumption, he really meant inference. It's kind of the same thing in this context, but he was not specific in how he applied that, and frankly, that bothers me, and that's really not something for an appellate court to do. We might defer to the trier of facts choice to apply negative inference, but we're not we're not in a position to make those discretionary decisions.
Remind me, and I will try to do that for Your Honor. In reference to the missing witness rule as well, to hold that such does not apply to bench trials and solely applies to jury trials would take out application in any type of workers' comp case, any type of termination of parental rights case, any divorce or custody matter, any general sessions matter, various probate matters that are requested to be by bench trial as opposed to jury trials. So I do think that such would be applicable in bench trials and is not solely a rule for jury trials. The courts that set forth the rule certainly did not state that it solely applies in jury trials.
Ms. Johnson, this is Justice Clark. Let me ask you one more question about application. Because the black letter law that some of our cases have recited is that if the other party has it peculiarly within his power to produce a witness that would naturally be favorable, then the failure to call the witness creates this inference. In this case, the facts I think that you have agreed to is that this gentleman was in custody. You say he was available to the other side because he could have been subpoenaed, but on the facts of this case, that makes him equally available to you. You could have subpoenaed him as well. So even if we find that the rule applies, does it actually apply on the facts of this case?
I think so, because this honorable court said that the rule applies if the witness is peculiarly available to the party who did not call the witness, and that there's a relationship between the party and witness that would incline the witness to testify for that party. To say that the opposing party would have a responsibility, and I do know that there are cases out there in Re, a state of Hamilton, which the Court of Appeals relied on, and a couple of others in reliance on that, have stated that the opposing party, if the opposing party had access and did not call the witness, then the missing witness rule doesn't apply. But I think that defeats the entire purpose of the missing witness rule, because the missing witness rule is to be held against the person who has the relationship with the witness that would incline the witness to testify for that party. So I respectfully think that the line of cases that set that particular factor out are in error based on the law as stated by this court.
And that is certainly something that makes it harder to have this discussion when the missing witness is a party. But so you just say that the peculiarly available language essentially comes out of the statute. It makes no difference and it has no effect on a fact situation like this?
No, I think that the peculiarly available only applies to the party who has the relationship with the witness that would incline the witness to testify for that party. The cases that cite the additional factors that were not set forth by this court in State v. Middlebrooks and State v. Francis, I believe are incorrect, because they just set out some additional factors. But there was one case, and I want to say it's the L-Shep case, that says that the appellants did not argue that that was incorrect law when that jury instruction was given. So I in this particular case, whether or not the witness was available to me, I think is not a consideration for the court under what the actual missing witness rule is, because there's no, if the missing witness rule is because there's an inclination for that witness to testify in favor of a party, to say that they're available to the other party defeats the actual missing witness rule, in my opinion. If that's all the questions on the missing witness rule, I will go to the unclean hands doctrine. And that is a doctrine of equity, a maxim of equity, and it's applied for the protection of the court. And in this particular case, the trial court applied it based on the numerous false statements by the defendant in his discovery responses and in his deposition that were proven by other proof. But what the trial court applied it to was the trial court specifically said that the defendant should be repelled at the courthouse steps from receiving any relief that he has requested in this case. He filed an answer, and in his answer, he made an affirmative relief or request for relief in the form of attorney's fees.
Johnson, this is Justice Bivens, but
Yes.
the chancellor made no such specific finding in his order, did he?
That was specifically in his ruling. I want to say it's paragraph 75.
He's saying he only applies unclean hands to the attorney's fees?
He did not specify that. He specified that he is barred or he is repelled from receiving any relief that he has requested.
Right.
And the only relief that he requested was an affirmative request of attorney's fees in his answer.
Well, couldn't you construe his request for relief to include a denial of the petition to terminate his parental rights?
I guess the court could. I don't think this particular court did, because where the Court of Appeals has said that the application of the missing witness rule and the unclean hands doctrine violated the defendant's rights to due process, he was represented by counsel at trial who chose not to bring him to trial. But he was still allowed to call witnesses, make objections, cross-examine witnesses, introduce evidence.
Well, counsel, this is Justice Kirby. The whole that whole line in the trial court's order bothered me because it's just unclear what. None of this case involves equitable relief. These are statutes. None of it is equitable. So how does that even come in? And so it worries me. I understand what you're saying, that his statement about unclean hands said to whatever relief the defendant is requesting, none of this is equitable. The doctrine just doesn't apply at all. So it bothers me that he would be throwing it out there and in such an imprecise way.
Well, I would submit to the court that a request for attorney's fees, an affirmative request, would be an issue of equity. If you
Ms.
come into
Johnson,
court- Yes.
I'm sorry. I didn't mean to interrupt you. Go ahead.
No, I was just going to say, if you come into court with unclean hands and you're requesting that specific relief, that is an equitable relief. I understand the line of cases with regard to children's issues, but the trial court did not specify that specific doctrine was applied in reference to.
That's not equitable. I mean, the chancellor may have some discretion in whether attorney's fees are awarded. That doesn't make it equitable relief at all. It's statutory relief pursuant to a statute.
In reference to a termination proceeding, I would agree, but I would still submit to the court that there was no prejudice to the defendant. If it is only applied and was only applied by the trial court as to any affirmative relief that he sought, which is what the trial court stated, then I do not believe that there was any prejudice. And I believe that if this court determines that such was an error, that it was harmless error.
Okay.
Ms. Johnson, I guess what I have is more of a policy question. I will say that, I handle some domestic matters as an attorney and as a trial judge. And even in this case, there are allegations that your client obstructed visitation of the appellee. So if we apply unclean hands to domestic matters, courts are going to spend half the time on those things instead of what's really important. So I guess as a matter of policy, why should we do this?
In reference to that particular issue, as I stated before, I recognize the cases that recognize that child-related issues are more prevalent in reference to the application of the unclean hands doctrine. I think the tenant case was one of the cases cited in reference to the unclean hands where there was perjury, and he was barred from the courthouse. He was barred from proceeding and participating in the trial. In this particular case, this defendant was not. I understand your question in reference to my client's, the application in reference to my client's emails and things of that nature that was raised. But at the trial of the matter, I actually raised the argument of the unclean hands because of the perjury. The defendant's attorney did not raise the issue of unclean hands with reference to my client. I mean, they made the arguments in reference to the grounds, but they did not make the arguments in reference to the unclean hands doctrine. So,
Well, I mean,
guess-
frankly, this is Justice Kirby. I don't see how unclean hands is applicable in a parental termination case at all. It's statutory. You look at the elements. So it just fuzzes up the whole situation to bring the doctrine of unclean hands into it. I do want you to address grounds, as Justice Page mentioned. I have serious concerns when I see a parent writing an email that says, "No money, no kid." That just jumped out at me. So I do want you to make sure that you spend some time addressing grounds, both failure to support and failure to visit.
I will. Any other questions, I guess, in reference to the unclean hands doctrine? Because again, I would submit that if the trial court was in error, that such was harmless error in this case, based on the trial court's specific ruling that it only applied to the relief that the defendant sought. On the grounds, and there are cases that set forth that termination cases are very fact specific. In that regard, there were two grounds that the trial court found. One was the willful failure to pay for the 4 months immediately preceding the filing of the petition. The other was the willful failure to visit that the trial court found immediately preceding the petition. With regard to the willful failure to support, the parties were divorced March 16th of 2015 by agreed order. The defendant agreed to supervised parenting time, and he agreed to pay $503.91 per month in child support, plus some other expenses, private school, and things of that nature. He worked at various places after the parties' divorce, but never paid any child support. The mother actually filed.
Excuse me, Ms. Johnson, is the relevant 4-month time period we're looking at August 19, 2016 to December 18, 2016?
Yes.
Okay, we know he did not pay child support. Is it correct? He did not pay child support those 4 months.
Correct.
So where the record shows that he had the ability to pay support? Court of Appeals opinion, there was no evidence that he was gainfully employed during those 4 months.
Well, his testimony at his deposition, he stated that in 2016 that he made $14,000. He made a couple of $100 from FedEx based on his the information that we received from FedEx. And that was through February 4th of 2016. He made $7,069.50 from his employment with Prime Flight from January 1st of 16 through May 3rd of 2016. Okay. So there was additional income.
But what did he earn between August and December?
I think that the court can infer that those earnings would have been after the May 3rd of 2016. He also testified he had he worked some odd jobs during that period. His mother also confirmed that.
Counsel, was he in treatment? Oh, this is Justice Kirby, sorry. Was he in treatment at Lakeside during part of that time?
No, he was in treatment at Lakeside from August 3rd to August 5th of 2016. There's also in those emails there are 4 emails that the defendant sent to the mother. On August 19th of 2016, he emailed and it stated he was on leave from work so he could do the full treatment program. He was not in treatment at that time, but he referenced that he was on leave from work. August 25th of 2016, he emailed and acknowledged that he had FMLA pay while he was off from work. And even the
Yeah, but he also had to pay for that treatment. I mean, the tenor of the trial court's order was trashing him up and down for his addiction. I understand that. But then in order to get treatment for addiction, you had to pay for it. I'm always concerned when the ground is failure to pay and a party is trying to thread the needle. Well, I mean, I'm just not, you have to show in a pretty impactful way that he had the ability to pay and he didn't pay. Do you concede that the proof does not establish willful failure to visit in light of your client's obstruction of his visiting?
I don't. In reference to that, there are numerous cases out there that basically say, you know, if he failed to seek relief from the court, which he did until well after the petition was filed, then, you know, his failure to visit is not, you know, can be considered willful. I will tell the court in reference to that, he has a duty to make every reasonable effort to arrange and assist. And
he has a duty to overcome your client's obstruction. Is that what you are trying to argue?
That is not what I'm trying to argue.
But that is the effect of what you're arguing, isn't it? I mean, your client is saying, no money, no kid, you better pay up. I'm not going to show up unless you paid this money. Clearly tying the two together, which is not permitted. And so your client, you're saying that he has the burden to overcome your client's efforts to, I mean, she wouldn't even tell him where his own child was living. I just have a hard time with that.
He knew where the child went to school. He did not go to the school until well after the proceedings had been instituted.
Ms. Johnson, this is Justice Clark, are you suggesting that if he had gone to school and attempted to take the child, that they would have let him go?
I didn't say
Wouldn't that have gotten him in more trouble?
I didn't say to take the child, but to visit. He made no other efforts other than sending emails. And there was no communication between August 25th of 2016 and September 13th of 2016. And if he was dying to see his child, he chose to take that opportunity to go to see his sister in Cincinnati. There was no communication in November, the entire month, between October 13th and December 14th of 2016.
So you're saying it was his duty every week or every 2 weeks to write again to someone who had said no money, no child, and say again, may I have the child, and receive again the answer, no money, no child?
I'm not, but I'm saying that if he was getting those responses and then he took an entire month off of doing nothing and he spent time with Emily McGee, which is the proof, and spent his weekend stealing her identity and, you know, committing crimes, then his choices are also part of the record. They are not just his emails and my client's emails back to him. He does.
But the burden of proof remains on your client. You're not trying to change that, right? The clear and convincing burden of proof remains on your client. All right.
I agree.
Thank you, Ms. Johnson. I think your time is up now.
Thank you.
Ms. Hall.
Good morning. Good morning, Your Honors. Abigail Hall, I represent the appellee, Mr. Looney. I will first be speaking as to the missing witness rule. I believe there are 3 issues that I would like to address as it relates to that point. Number 1 is that the missing witness rule should not be applied in termination of parental rights cases. Number 2, even if it should be applied, the appellants failed to satisfy the 6-part test necessary to invoke the rule. And number 3, even if it should be applied and the appellant satisfied the 6-part test, the trial court invoked the wrong standard. And that is certainly created more than a harmless error when we're dealing with the termination of parental rights and the grave stakes that are involved and inherent in those proceedings. There is no harmless error, in my opinion, as it relates to a termination of parental rights case.
Ms. Hall, this is Justice Clark. Let's start with, why didn't you either subpoena him or at the beginning of trial say, my client is unable to be here today through, I don't want to say no fault of his own, but he is incarcerated. He is not physically able to be present. I have tried to subpoena him and been unsuccessful, and I want a continuance.
Or let me amend that question, or
Yeah.
have the court issue an order
Yeah,
for your client to be transported that
across the
day,
street.
any day of trial across the street.
Yes. So I did. As soon as he was taken into custody and I realized that he would not be released prior to the start of our trial date, made an oral motion of the trial court when we were before the court on a motion to compel and resolving discovery issues, that the trial date be continued in light of his having been taken into custody. That motion was denied. We appear at the first day of trial. Chancellor Evan asks where he is. I say they will not transport him today because he is already proceeding to make an appearance before a criminal court judge, which, as you all are aware, is an undertaking, especially in Shelby County. And so there was no way to transport him on the first day of trial. As it relates to the subsequent days of trial, as I have stated before, that was a contemplated decision. That was not an oversight. It was not something that was forgotten. And
Did you ask for did you make an oral motion for continuance on that first day of trial?
no, the chancellor had already denied my request to continue the trial date based on incarceration. So I did not reassert the same request. What I did ask and made a written motion for is that the trial be bifurcated and that we start with what was, solely the petitioner's burden of establishing grounds by clear and convincing evidence until I could coordinate getting the criminal matter resolved or getting some sort of grasp on what was transpiring across the street. That motion was denied and the trial proceed full force starting day one.
So why didn't you have him transported on the second day of trial or the next 4 days thereafter?
Without getting into the communications between me and my client of what factors we considered when making that decision, I can say that the burden in a termination case under the statute that was in effect when this case was heard was entirely on the petitioners. He had no burden to prove that he didn't pay and then he had to prove that he willfully couldn't pay. No, it was entirely on the petitioners. And my position is if they needed his testimony to meet their burden, they had the responsibility of subpoenaing him to appear, which they did not do.
So Ms. Hall, you and client made a strategic decision that he would not be there to assist Ms. Johnson and her client in meeting their burden of proof. Is that basically it? So that you would not do anything to assist them in meeting that burden of proof.
Absolutely. I think you just a little bit, but if your question is, was he willing to do anything to assist them in meeting their burden of proof?
Well, no, I'm just saying it was better from your standpoint. You thought it was better that he stay away because had he been there, they would have called him as a witness to perhaps help them prove their case. And your client did not wish to do that.
He certainly did not wish to do anything that would help them, assist them in terminating his rights. And although there were pros and cons and risks inherent in him not taking the stand, certainly testimony that potentially could have been offered that would have been helpful, that was a contemplated decision that I just have to tread lightly because of course we discussed this at length.
Right.
And that's the decision that was made.
And the con of that would be perhaps a missing witness inference. I mean,
No.
the downside is that the chancellor, let's just put it bluntly, the chancellor might decide he did not care enough about his case to be there. That's the downside. And honestly, I don't think that's what happened. The chancellor just thought if the guy's not going to be here, he obviously doesn't care about this child. So there was a real risk to the decision you all made not to have him there.
I do not disagree that there were risks. However, as to could he employ the missing witness rule, I did not think and do not think that that was a proper remedy for the court to do. As to him not being able to personally appear and say, I contest these proceedings, he made efforts through hiring counsel putting on witnesses, including his mother and his sister to testify to relevant information, defending against the allegations made by the petitioners. He was not a no-show, no attorney, don't care, didn't participate in the litigation. This litigation lasted for years, and he was engaged strategically and meaningfully at every level.
Ms. Hall, this is Justice Page. If we disagree with you about the missing witness rule with respect to bench trials and in particular parental termination cases, how does that impact the outcome of your appeal here today?
I believe that my appeal to the Tennessee Court of Appeals ruled correctly that the missing witness rule is not applicable to termination cases. If Your Honor is asking how does it impact if you remand it back to the trial court to invoke the proper standard?
Well, do you think that if we disagree with you and don't remand it, is there enough in the record for us to decide the case based on the grounds that were presented at the trials or lack thereof as far as termination?
I do believe that the Court of Appeals did a thorough review of the record and found that the petitioners failed to establish that grounds existed by clear and convincing evidence.
Why don't you go ahead and enlighten us on that, unless you want to get into the unclean hands doctrine first, like your opponent did.
Well, I will go however the court instructs me. I did just want to follow up briefly on the missing witness rule and say that to the extent it applies, which I do not think that it should apply to a termination, given the heightened issue that's before the court and the possibility of someone's fundamental right to parent their child as they see fit being the issue before the court is tantamount to a criminal proceeding where someone's fundamental rights to liberty or freedom are before the court, and they invoke their Fifth Amendment right, and there is not a negative inference in a criminal proceeding. That is, to me, why is likened to this as to why the missing witness rule should not be applicable in a termination proceeding. That courts should not be invoking these equitable doctrines and rules that we have to protect the court and help in judicial efficiency and proceedings with juries when we have someone's fundamental rights at issue before the court. Again, as a secondary issue, they failed to issue a subpoena to him, which they could have done, which means they failed to satisfy the 6-part test necessary to invoke the missing witness rule because they had equal access. And finally, that the trial court invoked the wrong standard. This is not a tomato-tomato issue. There is a true legal distinction between a permissive inference and a presumption. It is clear, and that was actually set out very thoroughly in a case that came down in March from the Court of Appeals, Mon versus Tarquinio, where they went into great detail about how those two distinctions should be made, when they are to be made, and what the trier of fact is to consider when making a permissive inference, and what the trier of fact is to consider when making a presumption. And they are not the same. And so to the extent that it is applicable and that the factors were satisfied, the court simply erred, and it was not harmless in finding a presumption as to what his evidence would have been, as to what his testimony would have been. As to the doctrine of unclean hands, I think that TPR, termination of parental rights actions, are not equitable in nature. That certainly what is the point of the doctrine of unclean hands is to protect the integrity of the court, which is a good thing. However, when you have a child's interest at stake, those interests are paramount to the integrity of the court. The court has other tools at its disposal to address issues such as direct contempt or errors in discovery. Certainly they can make sanctions as it relates to discovery and such, but to hold the integrity of the court in those proceedings as superior to the interests of a child is not proper. The case law is clear on that. And I don't believe that the appellants have pointed out any case law that would contradict that position. As it relates to grounds and his willful failure to support, or his alleged willful failure to support and willful failure to visit, counsel addressed that he could have gone to the school. He did go to the school. He went to the school before he was served with the petition for termination of parental rights to go to a Christmas performance, just as a last ditch effort to do anything to see her. He went there. As soon as mother noticed he was there, mother was gone, child was gone, there was a commotion. Mother testified to this in her deposition. He did go to the school. It doesn't help that she, on school enrollment forms, listed him as a danger or a threat or put the school on notice in some way that he was not supposed to be there. That certainly doesn't help things. But regardless, he went, and he was trying, and he was trying, and he was trying. Certainly the petitioners, the Court of Appeals correctly held the petitioners failed to prove by clear and convincing evidence that he abandoned her by willful failure to visit. Abandonment is the statutory ground, the central inquiry of which is that the court must determine whether that abandonment was willful. His efforts were thwarted. She was an impediment to him seeing his child at every turn, at every turn.
What about his ability to support? According to Ms. Johnson, he earned $14,000 in 2016. Did he have income that he could have paid support between August and December 2016?
There was no evidence put into the record at trial that he had the ability or that he had income during the relevant period of time. Even to counsel's point where he cites in an email as to having received FMLA, I believe in an email at some point in time, during the relevant period, there was no proof put into the record that he ever received FMLA or from whom he would have been receiving FMLA and in what amounts.
Well, was there any evidence that he was disabled or not able-bodied and could not work during that period of time?
The evidence, and frankly, Ms. Godek admits that something was going on with him. And I think the court inferred based on his recent stint in a rehab facility during August that clearly he was struggling with addiction issues. That was not a secret to anybody, that was a struggle that he was dealing with. And I don't know that formally disabled was ever introduced, but certainly impediments that were inhibiting him from being able to maintain stable employment.
I mean, how was that put into evidence that he was not able to work?
I don't, again, based on what the statutory requirements were at the time of this hearing, the burden was entirely on the petitioners. And I do not believe that they proved that he was working, could have worked, had the ability to work, was able-bodied, was earning an income during the relevant period of time. That they simply did not have the proof at trial to support that. In the matter of In Re Ryland S., the Court of Appeals held that in light of the absence of proof of a regular income for father, we do not find clear and convincing evidence that supports the trial court's decision to terminate father's parenting rights on the ground of failure to support. Similarly,
Well, I guess my concern is that if we know he worked in the early part of 2016 and earned $14,000, did he just sit down in August through December and say, I'm not going to do this anymore? I'm not going to work, and therefore you can't prove your grounds? I mean, I can see where the chancellor might say, well, if you worked up until a certain point and then you quit working, maybe you had the ability to work.
certainly, I mean, I think that would be an inference, an assumption that the chancellor would have been making, because there was no proof as to what his ability to work during those 4 months was, other than what Your Honor mentioned, the fact that he earned income prior. But also, I think that it's worth noting that he was earning income that in January, February, March from Prime Flight and FedEx, and then he went to rehab. And so to the extent that the court is going to make an assumption that he had the ability to earn income, the court then would also have to make an assumption that he was struggling with addiction issues. And again, these cases should not be decided on assumptions. They should be decided on the proof that is admitted at trial. And had they called Mr. Looney to testify, and had he testified as to his income earning capacity and his health and his ability to maintain stable employment, we would be having a different discussion, but they didn't. And that testimony was never solicited at the trial.
Ms. Hall, this is Justice Bivens. Did I understand you correctly to say that even though your client sent an email during the relevant time period indicating that he was receiving compensation when he was on an FMLA, that there's no proof that he received any income during that time?
Correct. There was no proof that he was receiving FMLA other than, I believe, that the email that Ms. Johnson is referring to.
Well, it came from him though, didn't it?
Those were his words in an email. Absolutely. And I think, and again, I mean, this is an inference I'm making, but that these parties he knew based on her emails to him that his visiting with his daughter was precedented on him paying her substantial amounts of money. And I think that one could reasonably infer, again, that's a problem, but one could infer that he is trying to convince her that he is going to be getting money soon. Money's coming. It's in the mail. Please let me see her. Bring her to the rehab facility. Bring her to family day. Bring her to the police parking lot so I can visit. You know, that he was.
Excuse me. So you're saying he basically lied when he said he was receiving compensation while
No testimony solicited at trial as to that period of time, one way or the other, whether he was receiving FMLA other than that email.
Well, if in fact the missing witness rule applied, would that not be one area where the inference could be used to find that he did have some income during that period of time based on his statement in the email and his failure to contradict that?
Well, the missing witness rule, if it's applicable to termination proceedings, shouldn't apply because the appellant had it within their wherewithal to subpoena him to trial and confront him.
Well, I understand that's your position, but I'm saying assume for a moment that it does apply. Wouldn't that be a possible use of the inference in that situation?
It's hard for me to imagine inferences in termination cases. However, I think that the missing witness rule, when it's used in other manners, contemplates the totality of the facts that were before the court, which would include that email. Now, Mr. Looney would have been confronted with that email under the missing witness doctrine in this case, because the Mr. and Ms. Godek would have had to subpoena him to be at trial. But to the extent all of that is not a part of your question, then I would say, yes, theoretically, they could have looked at the totality of those emails and made inferences if the missing witness rule is to be applicable in termination proceedings, which of course I submit it shouldn't be. Again, as I've mentioned before, the purpose of the heightened burden of proof in these termination cases is to minimize the possibility of erroneous decisions that result in an unwarranted termination or inference with right, which is why I think that the burden having been on the petitioners to prove by clear and convincing evidence, not only that he willfully failed to visit, and that he willfully failed to support for the 4 consecutive months, should have been met with much stronger evidence than what was presented to the court. The petitioner should have not had to rely on these legal doctrines, the doctrine of unclean hands, the missing witness rule, to meet their burden. They should have been able to establish willful failure to support and willful failure to visit on their own without relying on these, I don't want to say nuance, but these other maxims that we employ in other types of cases. To ask for assistance in meeting that threshold and meeting their burden by invoking the doctrine of unclean hands and invoking the missing witness rule and invoking an inference as to was he paying, was he had the ability to pay, those things are not proper when someone's fundamental rights are at issue. And the heightened burden and the heightened level of scrutiny that must be met. As for his willful failure to visit, the record is replete with their communications and the offensive manner in which Ms. Godek was addressing him and his efforts to see her, his efforts to speak with her, blocking his phone number, moving, changing information at the school constantly. Certainly she took, and she admits, that she was mad at him for issues related to their divorce. She was frustrated with him because he wasn't paying support as she believed he should have. And as a result of that, she first filed a petition to modify the parenting plan and hold him in contempt. And she did that in the circuit court of Shelby County. She did that before Judge Weiss. Judge Weiss chose to hold him in contempt on certain issues related to the support and did not modify the parenting schedule. He simply clarified what weekends during each month he would exercise. Well, Ms. Godek has acknowledged she was not happy with that. Shortly thereafter, she decided that she would pursue a termination action. she took strategic action in pursuit of this termination proceeding. This was not something that developed organically. I mean, this was a divorce, a quick remarriage to Mr. Godek, an attempt to modify the schedule that failed, and then a decision to terminate that was methodically thought through and planned, was filed, was served, and was litigated for years, to the point that we're still litigating this now. But I think it is worth noting, because it was so egregious to the Court of Appeals, the speed at which this has all transpired. These parties were married for years before they conceived their child. They conceived her, they remained married for several years. Then the divorce, then the remarriage, and then this line of litigation that has transpired, and probably most likely to the detriment of this child, which I know is the central focus of what the court's focus should be. So I think it is worth noting that the intensity and the mass amount of thought and effort that has gone into this plays when we're talking about someone's willful failure to visit, and the amount of time that has gone into interfering with his ability to visit with his child.
Ms. Hall, this is Justice Clark, and I have one question that's slightly peripheral, and I'm not asking you to disclose anything not in the record, but as a part of the record, is there any proof that your client was indigent or that you were appointed under Rule 13 in this case?
No, Your Honor. Nothing in there that he was indigent, or that I was an appointed counsel.
Thank you.
There's nothing further, Ms. Hall?
Nothing further, Your Honor.
Okay, thank you very much. All right, Ms. Johnson, for your rebuttal.
In reference to the grounds, I do want to go back just with some of the facts, specifically with regard to his willful failure to pay. The only payments that Mr. Looney made to the mother after their divorce in March 16th of 2015 was a total of $696.66, which was taken by wage assignment in April and May of 2016 during periods of time in which he worked. If you look at the constellation of facts, which NRA PG says to do, I think NRA Maddox G also references the constellation of facts. You can look outside of the 4-month period to see what the willfulness of the failure to pay would be. We know that he was employed at both FedEx in 2016, early in 2016. We know that he was employed at Prime Flight in early 2016. We know what his expenses are or were because of his deposition testimony, and also because of his interrogatory answers, and his expenses were minimal. We also know that his expenses were being paid by his mother, who testified that she paid his expenses and did not request any funds from him. So he had funds to pay if you look at the constellation of facts during those periods of time, yet he did not do so. And in July of 2016, just before the period of time started to run, he provided his real estate agent with pre-qualification information for him to purchase and contract a $450,000 house. The purchase did not go through, but the fact that he provided pre-qualification proof to her shows that he had to have some income that he would have satisfied that requirement. He was held in civil contempt in February 4th of 2016, and he still didn't pay anything except for what was taken by wage assignment. When he was in Lakeside, August 3rd through 5th of 2016, his records reflect that he said he was drinking 20 to 45 beer per day. So he obviously had money to purchase that. The bank records that the Court of Appeals referenced, which had minimal balances in it, show that he traveled to Illinois, Iowa, Arkansas, and Missouri, all in the month of September. We know between August and December, when he was friends with Emily McGee, he had funds to travel to Florida to see her. We also know that he traveled to Cincinnati with his sister. So he had funds to do the things that he wanted to do during the relevant 4-month period. And I have shown that his income is greater than the income that we had at the employment through May 3rd of 2016 for that year. So there were funds available if his needs were being met and his expenses were being met by his mother. There's a case that I've cited that basically says that the mother was a stay-at-home mom and she was content and satisfied with her drug and alcohol addiction to allow her boyfriend to meet her needs. Well, I would submit that that's Mr. Looney, except that he was content with his drug and alcohol situation, but he allowed his mother to meet his needs. He had the ability to pay. The testimony showed he was able-bodied and able to work. Even his sister testified that he was able-bodied and capable of working. So he had the ability to pay. There was no proof in the record that he was disabled. There was no proof in the record really that he was unemployed during that period of time.
Well, this is Justice Clark. Does the fact that you stopped receiving any money by wage assignment suggest that he was no longer employed at that place, because you had an order down?
He was terminated from his place of employment at Prime Flight on May 3rd of 2016 because he left and didn't go back. But it doesn't show that there was no other employment after that. And the $14,000 that he testified that he earned in 2016, we only had proof of a little over $7,000 by May 3rd of 2016. His statements in the emails show that he was working in 2016 between August of 2016 and October of 2016. I think my time is up.
Thank you.
Thank you very much. Thank you both.
Thank you.
To those of you who are watching on YouTube. This does conclude our entire oral argument docket for the month of November. So at this point in time, we are ready to adjourn court. So Mr. Hibner, if you'll adjourn court for us, please, sir.